The focus of today's panel is obviously on state and local governments that have, whether they choose to acknowledge it or not, created a sanctuary zone within their respective jurisdictions, most often by refusing to honor immigration detainers filed against aliens who are arrested by police and sheriff's offices for crimes both serious and small. But sanctuary in many of these places goes far beyond detainer policies and often implicates how their entire organs of government interact with federal authorities on immigration matters generally, on everything from crime to social service benefits to health to education. Often, these sanctuary governments inhibit or downright prohibit their employees from exchanging information or communicating with immigration officials. In some places, they not only don't honor detainers, they go so far as to deny immigration agents full access to their detention facilities simply in order to interview inmates suspected of being deportable aliens. If we were to try and come up with a definition of sanctuary with that broader concept in mind, it might be this: any law, ordinance, rule, regulation, policy, or operating procedure that by intent or by effect inhibits, impedes, or obstructs federal immigration officials from performing their duties. I want to say that I dislike, and frankly intensely dislike, use of the word sanctuary to describe these policies, and that's because the phrase had noble beginnings going back to the far reaches of time, when the church was one of the few protections and restraining forces against the absolute monarchy. People who were egregiously wronged by the king could literally seek sanctuary in the sanctum of a church and be outside the king's reach. But it's important to remember that even with the church in those times, it exercised ecclesiastical powers every bit as powerful as those of the king, and it went beyond simply the ability to excommunicate. People who violated God's laws, which were in many cases indistinguishable from the king's laws, think the 10 Commandments here, faced corporal punishment, fines, or imprisonment by the church just as surely as from the king. There was no easy escape for criminals and malefactors who sought to abuse the notion of sanctuary. And what is happening now vis-a-vis state and local sanctuary governments is something different entirely. It seems to me more accurate by far to say that what they are doing is harboring and shielding illegal aliens, criminal aliens in the context of this panel. And they're shielding them and harboring them from the possibility of arrest by federal officers who are charged by law with detecting and apprehending them. Ironically, in viewing some of the many reactions and responses from police and law enforcement agencies to the map that CIS has posted, which, as Jessica has made clear, was prepared from materials provided by ICE, even as these officials balk at being called sanctuary sites and demand to be removed from the map, I've noted that many of them then go on to outline exactly the kinds of policies that do in fact prove that they're impeding effective immigration enforcement and compromising public safety, such as by insisting that criminal warrants or judicial orders must accompany detainers, and that is a red herring. Important as it is, deportation is a civil and administrative function, and for that reason, immigration law doesn't even provide for the issuance of criminal warrants against aliens who are wanted for deportation. And there's a logical reason for that. The immigration deportation system operates in parallel to the criminal justice system. If immigration agents were obliged to obtain judicial warrants or court orders for every one of the 11+ million illegal aliens presently in the country, the federal court system would be crushed into paralysis. Congress recognized that and instead has provided alternate means of establishing due process and probable cause. That those alternate means aren't to the liking of some state or local governments is immaterial, and it suggests a fundamental misunderstanding on their part of how the legal process was intended to work. So when local governments or state governments exercise such policies and insist on legal instruments that are not only unnecessary but completely unavailable under federal law, they are tacitly acknowledging their unwillingness to abide by what federal law does authorize and permit. But they are trying to mask their acknowledgement of that in a dishonest way, which is intended to divert the public eye from the true state of affairs, such as in San Francisco. Now, this state of affairs in which we find ourselves as the American public stems, in my view, from three causes. State and local officials who believe that they should be able to substitute their judgments for what federal immigration law permits or disallows, although they would be outraged if the circumstances were reversed. Second, litigious advocacy groups who have filed lawsuit after lawsuit with the express aim of wrecking the mechanisms of immigration enforcement that have worked to protect the public for so many years. And finally, a federal government that is so out of kilter that it sues states that are wishing to aid in enforcing immigration law, but permits sanctuaries to exist even at the expense of community safety. And it is this which has done incalculable harm to the use of detainers, and also through making public pronouncements to the effect that honoring detainers is voluntary, even though federal regulation clearly states that it's a mandate. Just yesterday at a hearing in the House of Representatives, the DHS Secretary admitted that although he preferred to view detainers as voluntary, neither his organization nor the Justice Department has absolutely any legal opinion to sustain that point of view, none. When I used the phrases harboring and shielding previously, I did so advisedly, because they're the words used in the federal statute that makes it a felony to smuggle or transport or harbor or shield from detection aliens who are illegally in the United States. The statute, which can be found at Title VIII of the U.S. Code, Section 1324, makes no exception for state or local officials, including enforcement personnel. State and local officials are as amenable to prosecution for violating the harboring laws as anyone. It could reasonably be argued that state and local officials are in fact held to a higher standard of conduct than the average man. Now, do I think that officials will in fact be prosecuted by the federal government under this administration? Absolutely I don't. But I raise the hypothetical possibility because if it was exercised just once, it would send the loudest possible message about the folly of organized attempts to obstruct federal law. I mentioned earlier how the administration has undercut the effective use of detainers. Most recently, Secretary Johnson has gone even further by directing that immigration agents refrain from using them whenever possible, even though they are lawful and, from the point of view of community safety, absolutely critical. The consequence of the combined actions of the administration plus unfettered and brazen defiance of federal prerogatives has resulted in a bloody hemorrhaging of alien criminals into the streets all across America. The murder of Kate Steinle was only the most recent of a number of such needless and preventable homicides. So what can be done to curb the trend toward state and local governments superseding their beliefs about what federal immigration law should be versus what it actually is? First, there must be congressional action. I know that several members of Congress have been introducing piecemeal legislation that focuses on detainers by directing that funds of one sort or another be denied to sanctuary jurisdictions. That may or may not suffice in the short run, but in the long run, there must be more. The Davis-Oliver Act goes further and provides other additional necessary counterbalances to ensure the public safety, including, I might say notably, providing immunity to state and local officers in their compliance with detainers and in their cooperation with federal immigration authorities. And I believe that is critical to them as well. Second, state legislatures could also take a strong position by enacting laws that authorize and direct their state and local officers to work fully and cooperatively with immigration authorities. And they could also establish their own immunity provisions within those state statutes. This would reverse the kind of trend that we have seen, for instance, in California with the Trust Act, which embeds in California state statute sanctuary policies. And then third, I think that victims and families of victims need to take a chapter from the litigious nature of advocacy groups. There must be lawsuits which are just as aggressive at halting law enforcement personnel from releasing alien criminals as there have been by advocacy groups bent on dismantling enforcement. Title 42 of the United States Code at Section 1983 says this in pertinent part. Every person who, under color of any statute or ordinance or regulation, custom or usage of any state or territory, subjects or causes to be subjected any citizen of the United States or other person to the deprivation of rights, privileges, or immunities secured by the Constitution shall be liable to the party injured. And certainly deprivation of life ranks right up there with constitutional protections. To date, to my knowledge, no family of a victim has used that statute to file suit. I personally believe that it might be appropriate in exactly such cases as what happened in San Francisco, where it was a Board of Supervisors ordinance and a Sheriff's Office policy that led directly to the release of the alien who committed the murder of Kate Steinle. That's it for me.